Good evening. Welcome to another episode of Awaaz in Focus, an initiative of Azaad Awaaz. This monthly patrika aims to focus on the marginalized sections whose voices are often muted in the cacophony of flashy mainstream media discourse. When referring to the marginalization, this platform does not aim to restrict itself to the traditional focus on social aggregates like caste, race alone, but aspires to include a discussion on class, gender, sexual orientation, etc. In this issue of Azaad Awaaz, we would like to focus on understanding and documenting the plight of the gig workers within India through a socio-politico-legal perspective and examine their place in the Indian economy. We would like to unpack the very term gig economy, explore the working conditions of the gig workers, the social security policies, and legal barriers in accessing them. Today we have with us Ms. Sabreen Ahmed, who is a lecturer in the Jindal Global Law School. She holds a master's in law from University College London. She has worked as a caseworker with the Intervene Project UK, an organization dedicated towards preserving the rights of the prisoners. She has also worked in the capacity of a legal researcher and legal associate with reputed organizations like Delhi State Legal Services Authority and other law firms in India. She carries a broad and comparative outlook on human rights. Thank you so much for joining us today, ma'am. With reference to the first question, while the term gig economy has garnered much attention in the past few years, there is no clear definition of the same. What are the risks and consequences of not having clear definitions of terms such as the gig worker? And also, how is a gig economy worker captured in the definitions of formal and informal economy that often get blurred here?
Right. We have to understand firstly that the world is currently growing. Not only we are living in a physically growing world, but we're also growing digitally in many ways. So the one problem of not defining who a worker is in today's day and age, I believe, is that the government gets a free pass from not providing the social security that the government or the state is obliged to provide in the first place. So if in case we become very rigid with the definition of who a workman is, not realizing that in today's day and age, especially freelancing has become one of the most prominent ways of working that allows the people to have that kind of flexibility when it comes to their work life. So one biggest disadvantage of is that all these workers who are falling within this emerging new terms cannot get social security benefits, which they would otherwise become eligible if they would fall within the traditional definition of a workman, which is understood more in terms of employer-employee relationship and the control test, which is very commonly also applied by the courts all across India. Now, one problem that is also prominent with respect to when you said that it kind of blurs the line between the organized and the unorganized sector. It's a very good question because when we bifurcate the sectors like organized and unorganized, then we still have a little bit of focus with respect to, let's say, daily wage workers. And we come up with new schemes with acknowledgement of this fact that they do not form part of the organized sector, or let's say the acknowledgement of the fact that they do not fall within the traditional employer-employee relationship. But the problem with gig workers is that they kind of fall right in between sometimes. And that's why create a gray area, which is not completely an organized sector, not completely an unorganized sector, because the terms of their employment are kind of very vague. They do not have an employment agreement. They have a workman agreement sometimes, which some of the terms of their agreement resembles that of an organized sector, a workman agreement. And some of the terms would be like, if I talk about, let's say, retirement benefits, etc., then a gig worker might not have those. But if you're talking about those industries where they're working, they're definitely falling in the within the purview of organized sectors. They are not necessarily not within the definition of unorganized sectors. So they're kind of piercing this line that was maybe there before, but now it has become more prominent. But the absence of special legislation which are realizing this difference is creating more of a problem for us to come to terms with, okay, that there are new class of workers emerging and they are not left or right, but like somewhere in between, and possibly require new sorts of protection with acknowledgement of the fact that they are indeed different in the way they work or function.
Thank you so much for your answer, ma'am. Moving on, the gig economy, especially in terms of the platform-based economy, is often said to result in democratization of the economy. Can it really be called as democratization, given that despite the surge in the gig economy, participation by women remains less than 30%? What factors can explain the invisibilization of women in the gig economy? And what should be done if the participation rate by women in the gig economy is to be increased?
Uh, I think it is the answer is very much would be similar to the answer that lies in other contexts. It's not just the gig economy where the women are invisible. There are many such areas where the participation of women is like considerably low. There are very few sectors where we see that women are emerging, education being one where I see that a lot of women are there. And then also there comes a question of intersectionality and representation amongst the women. Because let's say that no two women are different. Look at you and me. We are completely different. And this forms another question of representation. So when I talk about the factors that contribute to the women being invisible in this sector, I think they are the common reasons as to why they're absent in other sectors as well. One fresh reason could be that this freelance work or this gig work kind of brings in a lot of uncertainty, and women who are trying to break the glass ceilings, or who are trying to take up this financially independent roles, would definitely be looking for something that is more secured in nature. And in comparison to something that is temporary in nature is how we would, usually define gig work. So I think that's one of the things, but then it attaches itself to this idea that there's lack of awareness also amongst the women, because they might not know that such a nature of work would be available for them. Few of my experiences with people who have said that they would not, like women especially, they would not become, let's say, a Zomato delivery partner. They said that their home conditions would not allow it, because they can't possibly be out on the roads delivering food, and it's also a concern for their safety, because women on the roads are not safe. So if they happen to go to strangers' house and deliver foods, there's a sense of insecurity or unsafety that comes along with it. So I think they're not only an issue of financial insecurity, but also it comes with a lot of physical safety issues for the women. However, I would say that it's a very debatable point to kind of argue that how we can increase women's participation in just this particular sector. Well, we already know that there are so many other sectors lying idle of women's participation. But yes, I think the same sorts of resources would go for this sector also. That would start with awareness and a little more gender sensitivity in these sectors, especially. Like, for example, these sectors need to be equipped for women to be a part of it. And that would start with their physical safety, of course, which is everywhere, right?
Yeah, thank you so much for your insightful answer. And the next couple of questions would be focusing on the working conditions of the gig workers. So platforms such as the Urban Company keep track of workers' locations by accessing the GPS trackers in the smartphones of the workers. What are your views on this with regard to surveillance and violation of privacy and the resulting power imbalance? What are the other ways in which the right to privacy of gig workers is compromised? Should this issue be addressed, or is control and surveillance of workers inevitable in the gig economy?
It's a very interesting question. For one reason that personally, I think that I can never agree with this plain idea that something, the nature of the work especially is such that, so I can never agree with this idea that there cannot be certain amount of control on a platform that is digital. So a platform that runs mostly digitally would be having control digitally on their workers, would obviously be controlling them through these apps. However, the question that the breach of privacy cannot become an inevitable question, even if the question of control digitally is inevitable. So when I don't know you, and let's say you work for me, and there's only way for me to have little bit of control over you would be through a platform online, then it goes without saying that I would be tracking your presence because you're going to be delivering my products to the customers. Because let's say you're not in a customer facing role directly, the customer approaches the company and you're just the delivery agent. So in that sense, yes, it is inevitable, but breach of privacy can never be a consequence of it. So when I talk about that, it becomes important that not only these workers are made aware about what source of data are being taken, and whatever data is being recorded of these workers should be limited to the ones that is absolutely or inconvertibly required for them to keep a track, and only for the purpose of keeping a check on the delivery agents, let's say, if we're taking this example. So but lots of times it happens that there are many privacy breaches where their personal data gets shared here and there, and this also poses risk to their lives and their safety, and that can never be okay. So a certain amount of scrutiny is required as to how much data is being taken. The durations of tracking, like the tracking should be limited when an order is received and is being delivered, and not necessarily all the time. And then there has to be a way to determine for sure that, okay, once the person has completed the shift, the tracking has stopped. You cannot be tracking the person forever or surveilling his in and out activities all through the day. So yes, some safety measures, some scrutiny, and some sort of control over the amount of data the companies get to store and then sell out needs to be there. And it would be very much in alignment to the same arguments that we put forth whenever we talk about right to privacy and data breach in general sense. So yeah, I think that would apply even on the gig workers.
Okay, yeah, thank you. So moving on, campaigns such as hashtag ignore no more by platforms like Uber make them seem gender sensitive. How is this gender sensitivity to be understood given that most of the digital platforms do not give the workers social benefits such as maternity and menstrual leave, and the workers they hire are mostly men? Moreover, while these organizations have been vocal about gender based violence, the workers associated with them do not get assistance in cases of sexual harassment because they are not considered as quote unquote employee under the POSH Act 2013. Why is this disparity in terms of the gender sensitive policies there? And why are similar gender sensitive policies not made for the female workers as well?
Yeah, it's a very good question. Let me start with that. Yeah, I think there's definitely a sense of hypocrisy there if we are talking in terms of the kind of campaigns they promote and then their internal policies with respect to their female employees. As we also discussed in the previous one question, that these sectors are not equipped to have women as employees in them because one reason that, as you said, that they're not necessarily gender sensitive yet. And they run with this ideology that, okay, if we are hiring a delivery agent or a delivery partner, he would be a man. So yeah, that is obviously there. Now, let me talk about it a little bit from a posh perspective, from the Act's perspective. Now, if we see the definition of employer uh, under the Sexual Harassment Act, that is, employee, that's quite wide, right? And whenever we are talking about complaints to be filed under Sexual Harassment Act, then the definition that is read most importantly is that of an aggrieved woman. And if you read that, the definition kind of holds the ambit really wide, which I believe that could apply to the women who work in the gig economy as well. Now, I think what is lacking here is not the act not sufficing to kind of cater to this gender sensitive requirement of the law or the sector, but what is lacking here is the interpretation of this sector of this law in favor of the women, or more broadly, to cover the women who work in gig economy, if in case they fall into such a situation, and then they should be eligible to complain under the POSH Act itself. For example, the Act also leaves some amount of flexibility when it comes to where these women can complain. So obviously, when it comes to gig workers, there is a possibility there might not be an internal committee, but then there is a scope with women to file a complaint with the local committee. Now, the problem why this is not happening is because these sectors do not make it clear in their policies that these women can make a complaint under the POSH Act and can, avail this particular option through local committees, right? And I think to make it more clearer for the women, one amendment that should be made, it should be in the definition of aggrieved women itself, where it should just include that aggrieved women's definition should also include the women who are working as gig workers, or let's say freelancers, or having a temporary nature of a job on online platforms especially. So if in case we make it very clear through a legislative amendment, that could be a very progressive step in that direction. Until the time we reach there, because it's a matter of political will after all, whenever we are asking for a legislative amendment, before we reach there, I think it should be an obligation that has to be put on the companies itself, that not only they highlight these policies on the platform, but they also make their hiring policies very gender, fostering gender equality. And in order to do that, they need to make sure that women feel safe, as I said in my previous answer also, that their working conditions and everything should include these terms, that whenever a woman would face such a situation, these options would be available to the woman, and she can approach the local committee within the POSH Act itself.
Okay, yeah. So the next questions that I wanted to ask you would be specifically related to the policy implementation side. And so the first question is, in the Indian context, gig workers are given the status of partners or self-employed. Thus, they are not in tune with the legal definition of employees, and hence they cannot access the social benefits, as we already discussed this.
Yeah.
Gig workers are now demanding to be categorized as quote-unquote employees. Do you personally think that the situation will get any better if they come under the legal definition of employees from self-employed individuals? And are the organizations and platforms going to implement labor protection laws, given that this would most probably be unprofitable to them? And what is the role of the state in the same?
I really don't think that organizations will have a say in it if there is a central legislation being made that is more dictative in nature than directive, asking that the corporations or the companies need to comply with this particular requirement. So I really believe that, yes, expanding the scope of this definition of employees is really required, especially if it is an undeniable fact that, yes, we are kind of proceeding towards a very new world order, and the nature of work and the definition of workers is only going to change in the future. And especially when we are talking about AIs being hired as let's say professors in some colleges, and all sorts of things, that are all sorts of experiments coming up, and then there's a question of, will they fall within the definition of employees, and will they come with their social benefits or not? So if you're really living in an expanding world, which really has no say in how technologically advanced you are getting in with each passing day. I think in such a situation, it is important that we also make our legislations quite aligned with that kind of digital world that we are going to live in. And so far as gig workers are concerned, I really, really believe that control test is not the only test. And even if that test is being applied, as I discussed previously, that yes, they are under a very wider control of the company itself. And if we happen to include control over digital platforms, then they are literally being tracked to an extent where we are questioning the surveillance and privacy breaches of the employees. So I think it's all a matter of time when we start interpreting the control test broadly and start fitting these new emerging workers within the definition of traditional employer-employee relationships. And I think that organizations will implement it, because if it's a central legislation, then I don't think they have a say. They have to implement it, just as how labor law in general came as a social welfare legislation, and the companies had to really comply with it. For example, when it came to working hours, earlier they were exploiting workers by making them work for like a large number of hours and paying them less. Now they were benefiting out of it, but it did turn out a little unprofitable for them when they really started talking about their rights. But they still had to do it because it was a central legislation need. So I think when such a progressive step is taken in that direction, the companies will have to comply. And I don't think that it's going to turn unprofitable for them. I think it's only going to be profitable if it is looked from a social security angle, where you're hiring people of value and quality and all of that.
Thank you so much, ma'am. Following this, I want to ask that there has been a lot of development, especially in the labor movements, that has spurred in the last year in America in cases like Amazon. What do you think would be the possibility of such labor organizations happening in cases across the world, and at least in our case, in particular, India?
So, see, I think it is already happening. If we happen to go through uh, unions like People's Democratic Union and all such, they have been talking about the rights of gig workers and them to be included within definition of employer-employees as well. And there has been a protest also in the recent past where an NGO has very, on the forefront has argued that because the economy is emerging, we have no other option but to include them within the definition, because the nature of their work is getting very exploitative day by day. So I think, yes, there is a possibility for sure there. But I also think that there is a requirement of legislative intent and political will when we are talking about such a movement going anywhere or leading to something substantial. And since lawmaking in India is a tool that is completely out of our hands, I think we have another tool in the form of precedents that could, like the judicial precedents, could really set the tone of how we look at employer-employee relationships and the nature of their work from now on. I do understand that we only understand employer-employee relationship from the perspective of the control test, as there have been cases in the past. For example, if I have to cite few, Shivananda Sharma or uh, Darangadra Chemical Works Limited, all of these cases have interpreted control test as to be the most important test when determining employee relationship. However, there have been certain integrations and certain other tests also being applied by the court, one big organization test. So where it is examined that whether the employer or employee, whether the employee, the nature of work the employee is doing is integral to the part of the organization or not. And this test was applied in cases like Azaad factory, etc., where Supreme Court mentioned that it is just not about the control, but also about what value the employee is adding to the organization. Now, if I apply this organization test on the gig workers, I think these platforms are of no use if we do not have the Ola riders, the Uber riders, or the delivery agents. So from that perspective, I think their nature of work is taking the center stage here. So if I apply that progressive test here and not really determine the traditional control relationship that is required. And I think they very well fit into the definition of employee-employee relationship. It's just that we need these jurisprudence to like come to the surface and take the front seat now. And once this happen, I think this would change. Eventually, this would change the jurisprudence first, and then eventually it would lead to some legislative changes as well. And the social uproar or the need for inclusion of these workers is already there, even in India. And I think it's only going to grow from here on.
Thank you so much, ma'am. With this, I have asked you all the questions that I wanted to. And thank you so much for joining us today. It was a very, very insightful session.
It was my pleasure. Thank you.
Thank you so much.